quite a complex piece of legislation. So if you haven't quite understood the nuances of it, completely understand. Hopefully I'll be able to give you a general guide of how this bill, which is currently before the Senate, might be impacting the industry. So before I get to that though, a little bit of an overview of what the current situation is in terms of online content in the industry. So many of you may be aware that all online content is currently regulated by something called the Broadcasting Services Act. And one of the main features of that act is it says if certain types of content is on the internet, the e-safety commissioner, formerly ACMA was the regulator that was in charge of this, but a body called the e-safety commissioner can issue takedown notices for websites to remove content. And they also have a lot of other broader powers to do with deleting links from search engines and things like that. So there's this federal regulator called the e-safety commissioner, which is in charge of controlling content on the internet. The way that it currently works is the e-safety commissioner can issue takedown notices, ask you to take down content. If it is refused classification or X18 plus content, and I'll go through what that means. If it's R18 plus content, not subject to something called a restricted access system. So again, many of you may already be aware of some of this stuff, but I'll go through some of the terminology here. And even visual imagery that could be MA15 plus, so could be at that level. If it's not behind a restricted access system, it's susceptible to a takedown notice. The current scheme is fairly limited. So it can only issue takedown notices for content that's hosted in Australia. And up until recently, there was an assumption that social media websites weren't subject to these sorts of takedown notices. And that's likely to change with the online safety bill. So currently, if you have explicit content on the internet, you are putting yourself at risk of a takedown notice. But it's constrained to Australian websites and it doesn't cover social media. And Eros has probably maybe one member a year that has an issue with takedown notices, but the current law does allow it. Now, just for your purposes, the e-safety commissioner, the current head of the e-safety commission, the e-safety commissioner is Julie Grant. And I'm highlighting her personally because her public statements recently are somewhat reassuring in terms of how the e-safety commission is going to act in the short term. She's the current head of the regulator. Many of you, probably more so than I do, would be aware of the history of Australia's classification law. That is how we categorize different forms of media and the consequences of categorizing media as X or R and all of that sort of stuff in terms of law. Strangely enough, anything uploaded onto the internet, whether it's a static image or a moving image, is classified in accordance with film classification guidelines. So those of you from back in the day and who were commonly selling DVDs and things like that, it's that old classification code to do with what applied to DVDs and videos, that applies online under the current law. And there's lots and lots of issues with the current classification laws. Infamously, a lot of consensual adult sexual activities is unable to be even X18 plus. It's refused classification and prohibited throughout Australia. The refused classification category includes depictions of fetishes, which is defined incredibly broadly under the guidelines as such as the application of candle wax, golden showers, bondage, spanking, and fisting. So it's very, very broad what counts as a fetish for the classification guidelines. Also encompassed are fictionalized incest fantasies. So any imagery which has things to do with, say, like step brother and stepsister or stepmom, all of that is refused classification and prohibited. And any sexual practices which are offensive or abhorrent to a reasonable adult also could be refused classification. For some of you, there's also guidelines around material promoting or encouraging drug use. That can also mean that your imagery is refused classification. And I'm emphasizing these classification categories because they matter a lot to the Online Safety Bill. So that's RC, or refused classification. The other categories that you need to be aware of are obviously X18+, which is any content which depicts actual sexual intercourse between consenting adults. So anything that would be classified, I think, colloquially as pornography is likely to be X18+, unless it's a fetish or falls within the RC guidelines. Then we have R18+, which encompasses simulated sexual activity and nudity. And I note that because I think a lot of advertising for adult retailers and brothels and adult businesses may not always fall into an X18+ category, but it's very, very likely to fall into an R18+ category. And so it's important to keep in mind that that impacts you as well. So these guidelines are currently subject to a review. It was meant to come back mid last year. It didn't. We don't know when we're going to hear about how the Australian classification guidelines are going to change. But it's important to keep in mind that these guidelines are viewed as so outdated that we have a federal inquiry happening to try and change them and update them so that they're more in line with community standards. Also, just to note about the current law is under the current law, there's common references to what's known as a restricted access system. So if you run any type of website which potentially could have R18+ or above content, which I think would be most of you, under the Restricted Access System Declaration from 2007, you need to have a restricted access system. Now, many of you may be a bit surprised by that, but a restricted access system is defined incredibly broadly. I'm not going to read out all the parts of that there, but it's defined incredibly broadly in such a way that this type of age verification, where you ask someone to input their date, or you ask whether or not someone is over the age of 18, under the current system, that's sufficient for a restricted access system. So that's a broad overview of what the current laws are. So that currently you're susceptible to a takedown notice if content is hosted in Australia. It doesn't encompass social media websites. And we only really know in terms of obligations for a restricted access system that this kind of minimal amount of restricted access system is sufficient. That's all likely to change under the Online Safety Bill. So, background and history in relation to this bill. It was announced on the 23rd of December 2020, so 2 days before Christmas. And consultations were open in relation to the bill. Consultations closed early last year. It is not just to do with adult content. Okay, so the vast bulk of the Online Safety Bill, and this is what's made it very difficult to lobby in regards to, the majority of the Online Safety Bill is tackling online harms such as cyberbullying, non-consensual sharing of intimate images, sometimes called revenge porn, online abuse, terrorist recruitment videos. It's dealing with online content that is really clearly harmful. And it broadens powers in terms of being able to issue takedown notices for those online harms. However, It also includes a Part 9, and you've probably seen in all of our correspondence that we're talking about getting rid of Part 9 or removing Part 9 from the bill. And Part 9 takes all the stuff from the Broadcasting Act that currently exists, puts it in this online safety bill, and then expands out the powers of the e-safety commissioner to take down content. The bill was introduced in the House of Representatives on the 24th of February, 10 days after the consultation period closed. There were hundreds of submissions in relation to this bill, the vast majority of them from sex workers and people involved in the adult industry, and they were ignored. The bill has passed the House. It passed the House of Representatives on the 16th of March. It's currently in the Senate, and it's likely to be debated in May and possibly passed in May to become law. So I want to kind of go through why we're concerned about this Part 9 in the online safety bill in terms of the industry. So Part 9, it's moving away from the language of talking about RC and R18 plus and X18 plus content. So we kind of have to get used to talking about Class 1 material and Class 2 material. Class 1 material is things that would be refused classification. So that includes all that fetish content that we talked about earlier. Class 2 material includes things that would be classified as R18 plus or X18 plus. So any kind of sexually explicit media, even if simulated, would fall under Class 2. For Class 1 material, the e-safety commissioner's powers have been expanded so that they can take down content now, if it's Class 1, if it's fetish content, whether or not it's hosted in Australia. So many people running porn websites had been working under the assumption that if they had an overseas website, they were safe. If you are producing Class 1 material, fetish content in any way, you can have material taken down whether or not it's hosted from Australia. In relation to Class 2 content, which I think applies for most of you, including retailers, you are susceptible to a takedown notice if your content isn't behind a restricted access system. Importantly, this bill anticipates that a new restricted access system will be coming into effect in the near future, and we have no information as to what that will encompass. And I'll talk about that in a little bit further in a moment. Most worryingly, and this is one of the main reasons that we're most concerned about everyone in the industry being impacted by this, the changes in relation to Part 9 mean that the e-safety commissioner can take down content on social media websites, Facebook, Instagram, Twitter, any social media website that you're using to advertise your business. The e-safety commissioner can now issue takedown notices in relation to that content. If the company doesn't take down that content within 24 hours from a complaint, it risks a fine of 500 penalty units or $55,000 per contravention. Okay, so if you're Twitter, someone's complained about a post on Twitter, if you don't have enough resources to take down that content within 24 hours, the business is hit with a $55,000 fine. So the biggest concerns that we have in relation to social media is less someone making a complaint and a takedown notice being issued to a website per se. We're less concerned about that. We're much, much more concerned about social media websites like Facebook, Twitter, and Instagram looking at this change of law, realizing that if they don't take down some of this sexually explicit content within 24 hours, they're going to be hit with a hefty fine, and shifting their policies to essentially purge anything that is sexually explicit on their website. And I think we all know the way that that social media policies deal with adult content is always incredibly clunky, incredibly broad, and it's likely to encompass lots of things that you think, you wouldn't normally think would be encompassed. So that's our biggest concern of this bill passing, that social media companies will overreact and they'll purge anything adult related from their websites. And we've tried contacting representatives from Facebook, from Twitter, all the social media websites, and no one wants to talk to us, which is making this a lot more of a concern on our end. We also have concerns about this proposed new restricted access system and what it could look like and what could be required. There was an age verification inquiry either last year or the year before. I think it might have been the year before. During that age verification inquiry, some of the suggestions for how websites should verify age were pretty ludicrous. There was a submission by the Department of Home Affairs that wanted to implement facial recognition technology in order to confirm someone's age. There was a lot of talk about the UK model of having essentially porn cards that people purchase in order to access content. And it's likely to be some sort of burdensome set of requirements mandated by law if there is a restricted access system implemented. So we're concerned about what that's going to look like. After I've just scared the shit out of all of you, let me just reassure you a little bit. We do have at least some reassurances from the e-safety commissioner that takedown notices in relation to adult content is not a priority. So because of pressure from Eros and particularly a lot of the sex worker organizations, the e-safety commissioner has said that she is not overly concerned with the sex industry. Although if a complaint is made to the e-safety commissioner, they have to act on it. So although the e-safety commissioner is saying that she's not going to be proactive in relation to taking down content, it will be a complaints-based process. Also in relation to the restricted access system, Josh Taylor from The Guardian has been very keen to clarify what that actually means. And we at least have some preliminary statements from the e-safety commissioner that facial recognition is off the table as a potential restricted access gateway. So the most extreme outcome is a lot less likely, but they are still pursuing some sort of restricted access system. So one of the things that I do want to note in relation to what we've currently got, there's this bill happening. I should note that there's no clear opposition from the Labor Party in relation to the bill. The online safety bill, from my perspective, is likely to pass. And even if we have reassurances from the e-safety commissioner that her office isn't going to misuse these powers, future e-safety commissioners absolutely could, because the bill is empowering them to take down content in different ways. And even though we have these reassurances by the e-safety commissioner, at this stage, we don't know how social media websites are going to react to the passage of this bill. And there is a real risk of some kind of content purge in order to avoid being penalized if this scheme is put into place. And as I said, there's going to be some sort of restricted access system, but we have no clear information about how that's going to be implemented. All we know is that the e-safety commissioner has been told to consider a restricted access system, at least within the next 18 months. So that's probably not going to happen immediately, but it's something to keep on your radar. Before I go to questions, just a couple of things. People often want to know, what can they do in this situation? Well, it's still in the Senate. It's going to be debated in May. It would be great if Labor senators had a change of heart in relation to this bill and opposed it in some way. As I said from the start, there's a lot of good things in the online safety bill. So the message that I've been trying to convey to lawmakers is just remove Part 9. You know, you can support all of the things that you like about this bill, but just acknowledge that Part 9 is maybe going into a more censorship territory, and implement a new piece of legislation that deals with that. Take out Part 9 is the message we want to send. So if you're wanting to be proactive in relation to this, I do recommend contacting Labor senators and crossbenchers in the Senate. In the information sheet that I think was sent out to you guys in relation to this meeting, I do give you a link of how you can contact your senators to get them to reconsider Part 9 of the bill. However, at this stage, because of various political reasons, both major parties are supporting passage of the bill, and it's likely to pass in May. And then the strategy is, the kind of backup plan is ensuring that it doesn't result in any kind of social media purge for the industry.